This morning we'll be talking to you about charity law, and Louis will speak first, and he's going to talk to you about what you can do if charity trustees believe that one of their number is no longer appropriate, but the mechanisms for removing that trustee are inadequate. After that, I'll then talk to you about charity schemes. If at any point you have any questions for us, please do click on the Q&A button at the bottom of your screen and type them out, and we will do our best to answer them at the end of the webinar. Without further ado, let me hand you over to Louis.
The problem I'd like to speak to you about today arises out of a story which was widely reported and which some of you may have followed. It concerns the dispute between the Dean of Christ Church, the Oxford College, and the governing body of the college. Now, this is a very strange story. It has all the sort of ingredients of a three-part BBC drama, and it's already been made into a podcast, which you can track down on Spotify. But it also raises some important and I think interesting problems of charity law, and that's the dimension I'd like to focus on today. So the plan for my talk is going to be first to explain what happened, and then I'd like to identify the main charity law issues which arise here. Pausing there, the two issues which have been most prominently reported on in the press, and indeed in the Charity Commission's own response, because it led to the issuance of an official warning, are about oversight and accurate accounting. But the more interesting issue, to my mind, which I've called the problem of the recalcitrant office holder, is this. What can or should charity trustees do when a fellow trustee, particularly a trustee with a senior governance role, has lost their confidence, refuses to leave, and the existing mechanisms for removal are inadequate? And that's the question that I'd like to spend the bulk of my time discussing. So let's turn to the facts. Christ Church, as you probably know, is an ancient institution. It was founded by King Henry VIII in 1546, and it's novel in that it's both a constituent college of the University of Oxford and the cathedral of the Diocese of Oxford. And of course, it's a registered charity, and that's why we're interested in it today. I think that the root of the problems, which I'll come on to describe, really lie in the governance arrangements of the college. So I'll say a short word about that. The government of Christ Church is vested in what's called the governing body. That is the ultimate decision-making body, and it's a group of around 60 members who are all individually the charity trustees. And they are the dean, so the sort of head of house, who's an ordained Church of England priest, the canons, who are the sort of subordinate clergymen attached to the cathedral, most of the academics, and finally any co-opted college officers. Now, the dean is the chair of the governing body. He has up until recently, it's always been a he, but I think it's now she. They have the casting vote, and they're responsible for the order and discipline of the college and the general superintendence of its sort of affairs, and for the use also of the cathedral as a place of worship. Now, the dean is appointed by the Crown, but the Crown has no power to remove them. Unless they resign or reach the mandatory retirement age, the dean can only be removed by the following procedure. So 7 members of the governing body may make a complaint seeking the removal of the dean for good cause. And good cause, as defined in the statutes, includes, and this was the limb that was most relevant to this dispute, conduct of an immoral, scandalous, or disgraceful nature incompatible with the duties of the office, and also a limb relating to effectively refusal or inability to carry out their functions. Now, if the governing body and also the chapter, so the cathedral part of the college, are satisfied that grounds exist, they appoint a tribunal to determine the matter. Now, let me turn to the dispute itself. The origins of this dispute are sort of murky, and as with everything else about this, hotly contested. So the dean has claimed in interviews that the problems began when he was left to deal on his own with a serious welfare incident and proposed reforms to the college welfare policies as a result. And that's said to have led to tension. And the governing body has said no. They've completely denied that. And they've said that the dispute originated with the conduct of the dean in connection with a pay dispute, because the dean felt that he should be paid in line with other heads of houses of other heads of houses of Oxford colleges. For present purposes, it doesn't matter, because regardless of what caused it, it became tentacular. It consumed the college between around 2018 and February 2022, when the dean finally left. And it visited almost every conceivable forum for making an allegation against a charity trustee, from the courts to the Church of England, via the Charity Commission and the police. So it begins with the Smith Tribunal. So this was a tribunal convened to consider whether the dean had been guilty of conduct of an immoral, scandalous or disgraceful nature. So note the high bar: immoral, scandalous or disgraceful, in connection with a pay dispute. So the tribunal was chaired by a retired High Court judge, Sir Andrew Smith, and he concluded that the dean's conduct fell short of that high bar. In February 2019, the dean then brought proceedings in the Employment Tribunal against the college, but really targeted at the other charity trustees for disability and religious discrimination, and to try and recover his legal costs of the Smith Tribunal. Then in October 2020, the dean was accused of sexually harassing a student, and the dean denied these claims, but a further tribunal was convened by the governing body. And in the meantime, the governing body commissioned another review, an external review by the president of Welsh tribunals, to consider whether it had acted properly in convening that other tribunal. And that review, that external review, concluded that it had. Now, the Church of England then triggered its own disciplinary procedures under what's called the clergy disciplinary measure. That didn't go anywhere, given that the Christchurch proceedings were underfoot. And a complaint was also made to the police. But the police concluded that there was insufficient evidence to pursue the investigations. Now, what's important to realize about this is that you have these separate strands to a dispute, but it became one enormous sort of explosion, which created an atmosphere of mistrust fed by crazy allegations of cabals and conspiracies, and the whole thing was fed by leaks to the press. Both sides reportedly asked the Charity Commission to intervene, but its response was basically mediate. We expect you to engage in mediation, and we're not going to get involved. And so they did, no less than 4 times. And the dispute was finally settled, as I said, in February 2022. And Christchurch is reported to have paid just under £1.2 million to the dean, on condition that he discontinue the proceedings against the college and that he vacate his office. And Christchurch, I should say, also reportedly paid an amount by way of settlement to the student who made the allegation of sexual harassment, because that complaint was never, well, the tribunal never came to a conclusion on that. Can I turn now to the charity law issues? So over the life of the dispute, Christchurch spent something like £6.6 million in charitable funds on the settlements, but also on legal fees and on the fees of other advisors, in particular PR advisors. And that resulted in the Charity Commission issuing Christchurch, that is the individual trustees, the individual charity trustees, the members of the governing body, except the dean, with an official warning under section 75A. And the commission had concluded, and you've got the text of that on the slide, but the commission had concluded that there were failures sufficient to amount to misconduct or mismanagement. And these are terms of art for the commission, and you've got the definitions from the commission's guidance at the bottom of the slide. But the concern, what led to this official warning being issued, was less, I think, with the amount of the spending itself, and more really with 2 elements: a failure of oversight. The charity trustees were said to have failed to have close oversight of the costs that they were incurring, So, for example, around £5.3 million of this was apparently approved retrospectively. So having been incurred, the governing body convened and then approved it retrospectively. There was no fixed budget throughout this dispute, and the charity trustees, when asked by the Commission about their expenditure, were unable immediately to provide the information. So a failure of oversight. Secondly, a failure of reporting. So this £6.6 million in charitable funds was reported in the charity's published accounts as relating to other direct costs, teaching, research, and residential. That was the categorization. Teaching, research, and residential. In circumstances where the charity trustees had apparently been advised by their auditors to consider specifically reporting on this expenditure. So those failures, as I've said, were sufficient to have amounted to misconduct and/or mismanagement. And the remedial action identified in the official warning was to complete a full independent governance review, which I think has now been carried out, and to implement its recommendations and ensure going forward that the financial reporting was adequate. The real sanction, though, and you'll understand this if you've seen the reporting that came afterwards, was the publication of the official warning, which is where all this information comes from. It was sort of all set out in a press release by the Charity Commission. Now, from a charity law perspective, this is pretty familiar territory. Okay, the Commission's guidance about how charity trustees should oversee and report expenditure, particularly expenditure on legal proceedings, is clear enough. It's also clear that regardless of the specific operational arrangements for the governance of a charity, responsibility ultimately lies with the charity trustees collectively, which is why this official warning was issued to them collectively. And I think that the root of the failure here, and this is why the Commission recommended or instructed the College to carry out a governance review, was that decision-making in connection with the dispute appears to have been concentrated among a few officers, but responsibility for those decisions was diffused among all the members of the governing body, who were probably less involved in the day-to-day dispute with the Dean. But the more interesting and I think difficult aspect, which I referred to at the beginning of my talk, is I think this, and it's what I've called the problem of the recalcitrant office holder. Regardless of the merits of Dr. Percy's complaints, and regardless of with whom responsibility ultimately lay, Dr. Percy the Dean, had lost the confidence of the governing body which he chaired. And that clash undermined the charity's work and reputation. It became all the more serious because it lasted for so long. Dr. Percy was unable to carry out his duties as Dean for most of this period, so around 4 years, because he was either suspended while tribunals were convened or excluded from the work of the governing body due to the conflicts of interest resulting first from the pay dispute and later from the proceedings which he brought against the college. So what can you do in that situation? What can the charity trustee do where a charity trustee with a governance role has lost the confidence of their fellow charity trustees, is not failing to act or incapable, but refuses to leave, or refuses to leave without a settlement which the charity trustees consider to be excessive, and the existing internal mechanisms for his removal are inadequate? Now, I think this question is particularly relevant to charity trustees who are not personally involved in the dispute, who have no skin in the game in that sense, but they've concluded that it's in the best interest of the charity for the recalcitrant office holder to resign. And I'm afraid my slides have jumped straight to what I'm about to discuss next, but what I'd like to consider first are the duties of the charity trustees in this respect, and then the courses of action which are open to them. Now, the overriding duty of the charity trustees is to further the purposes of the charity. And they must exercise their powers in accordance with that duty. Let's take the situation first where a charity trustee has an express power, or charity trustees have express powers of removal of a fellow trustee. I think there's a strong argument that power is a fiduciary power, meaning that it must be exercised to further the purposes of the charity. And there's some Australian authority to that effect, albeit in the context of private trusts. I think it also follows from that, if power of removal is a fiduciary power, that the trustees should consider from time to time whether to exercise that power of removal to further the purposes of the charity. In our situation, though, the difficulty arises because the charity trustees either have no such power, or as with Christchurch, that power would require them to establish wrongdoing or mismanagement of which there may be none. There may be none at all. There may just be an argument, a dispute, people don't get on. Or there may be insufficient evidence of wrongdoing or mismanagement, such as to engage the power. So in that situation, in theory, you have two options. The charity trustees could call on the intervention of the Charity Commission, or they could apply to court for the removal of the trustee. Let me take those in turn. So the Charity Commission, in principle, has powers of removal, but they have a regulatory slant. So the Commission could order an inquiry under Section 46 of the Charities Act into the affairs of the charity. It could thereafter exercise its power under Section 79, which you have on the slide, to remove a charity trustee for protective purposes. And for that power to be engaged, the Commission would have to be satisfied that the charity trustee was guilty of misconduct or mismanagement, which we talked about earlier, or that the conduct of the trustee contributed to or facilitated misconduct or mismanagement. But that requires an inquiry. Things would have gotten pretty bad to reach that point. And the Commission also has the power to make a disqualification order under Section 181A, where the statutory criteria are met. And again, this really relates to wrongdoing, but wrongdoing which is a sort of where there's a public interest element in disqualifying an individual from becoming a trustee. And in that situation, the disqualified trustee could thereafter be removed under Section 79A. So we have these powers, but they have a sort of a regulatory slant. The other difficulty is that the Commission's own view of its role in a situation where the charity trustees are locked in an internal dispute is that its role is limited, and its operational guidance, which you have on the slide, indicates that it will effectively do two things. First, as a matter of course, it will say to the charity that it expects the parties to mediate or to engage in some form of dispute resolution. And it also says that only the courts can adjudicate on the issues between them, which is why I haven't referred here to the Commission's concurrent jurisdiction with courts to remove a trustee under, I think it's Section 69 of the Charities Act, because what the Commission's guidance says is in a situation of an internal dispute, it won't get involved in deciding who's right. So I don't think it would exercise a power which it shares with the court if it's leaving that, that determination to the courts. The guidance also says something else. It says that the Commission will not normally intervene in disputes unless, in line with its regulatory risk framework, it concludes that matters are so serious that an inquiry or some form of regulatory action is warranted. And in a sense, that's logical, right? It just takes us back to the legislative basis for the intervention of the Commission, which would require an inquiry or a disqualification order to be made. And this, I think, is what we saw with Christchurch and the Dean. The Commission was asked to intervene. Its response was, you need to mediate. So that leaves the courts. And the courts have the power to appoint a new trustee in substitution of an existing trustee under Section 41 of the Trustee Act 1925. The court can also remove a trustee without a replacement if sufficient trustees remain, and that's under its inherent jurisdiction. And it could also, in principle, direct a managerial scheme to alter the administrative provisions of the charity's governing document. What I have in mind here is that it could change the provisions governing the removal of the recalcitrant office holder. But an application to remove straightforwardly the trustee is almost always going to be more appropriate, simply because that's the relief that you'd be seeking. Now, I think it's worth looking at how these powers are exercised in the context of private trusts to understand how they might be applied in the context of charities. In the private trust context, in considering whether to remove a trustee, the court will consider whether the continuation in office of the trustee is detrimental to the interests of the beneficiaries. And the leading case here is Letterstead and Brewers. And this is a Privy Council case from the 1880s. And you have the extract here of the critical passage from Lord Blackburn. Now, in this case, a beneficiary had brought an action for the removal of a trustee, and there was insufficient evidence of the most serious charges against them. But the ensuing hostility between the trustee and the beneficiary meant that the continuance in office of the trustee would prevent the trust from being executed. And so the Privy Council ordered that the trustee should be removed. And in doing so, it accepted that friction or hostility between trustees and the beneficiary is a relevant circumstance. It can be taken into account in deciding whether it is necessary for the welfare of the beneficiaries for the trustees to be removed. That's the test. What Letterstead also tells us is that friction can be particularly relevant where it results from the way in which the trust was executed, relevant to the question of whether the trustee should be removed. Now, I think that the same reasoning would in principle apply whether friction was between trustees, rather than, as in Letterstead, between trustees and the beneficiaries. In our situation then, a critical question is still going to be the cause of the breakdown in the relationship. In a long-running dispute, which is tortured by the sort of accretion of accusation and counter-accusation, it may be impossible to attribute responsibility with any degree of precision, or more importantly, to satisfy the court of who should be removed in order to get rid of the difficulty. Here, I think the way around that is to bear in mind what will actually happen. In practice, the Commission will order you to mediate. And where the purpose of the mediation is simply to excise a trustee with whom the relationship has deteriorated, a settlement offer will, as a matter of course, frequently be made. And so the obstacle to removal is likely to be, in practice, that the recalcitrant office holder is insisting on what the other charity trustees consider to be an excessive settlement payment. And that gives you a way forward, because in that situation, the charity trustees could seek the advice of the Charity Commission under Section 110 as to the terms of the settlement. And if the Commission were to advise against entering into a compromise on those terms, on the terms on which the recalcitrant office holder insists, that could prepare the ground for proceedings to remove the charity trustee. I think in practice, that may also be a necessary step, because it may be a necessary step to involve the Charity Commission, because any such proceedings to remove the charity trustee would be charity proceedings within the meaning of the Act. And so they would, in any event, in the first instance, require the consent of the Commission to bring them. So in those circumstances, I think the unreasonable refusal of a settlement offer, particularly where the Commission has advised the charity trustees not to make or accept that offer, is likely to be the linchpin for asking the court to remove the recalcitrant office holder, even in circumstances where it's difficult to attribute blame. And this sequence, mediation, settlement offer, unreasonable refusal, application to the court to remove, may also, I think, frequently in practice chart a course for charity trustees who, faced with a recalcitrant office holder, try to determine what they can do and what they ought to do. And that, I think we'll come on to questions at the end, but that is all I wanted to say about that. So I will hand you over to Matt.
Thanks very much, Louis. Good morning, everyone. As I said, my name's Matt Mills, and I'm here to talk to you about charity schemes. And I'm going to start in ancient Rome. In about 220 AD, a Roman city received a very large legacy, subject to a condition. The condition was that the money should be used every year to host games to commemorate the donor's life. But as a matter of Roman law at that time, that type of thing was illegal. So what should you do? Step in Modestinus, one of the 5 most respected jurists of the ancient Roman world. His advice was in the following terms. It was unfair that the sum which the deceased had intended for the spectacle should fall to the profit of the heirs. Therefore, the heirs and the chief men of the town should be summoned to discuss how the legacy could be transformed so that the testator's memory would be celebrated in some other legal way. Now, we'll never know the history for sure, but it has been argued that this passage shows that the idea of si pre, which is one of the topics I'll talk about today, can be traced back nearly 2,000 years to Roman law. But I promise I'm not going to spend all morning talking about Roman law. Instead, I'm going to cover 6 modern issues. I'll explain what the main types of scheme are. I'll explain which types of charity can ask for a scheme. I'll then give examples of when you might need a scheme and when you might not need a scheme. I'll then explain the rules applying to si pre schemes and then administrative schemes. And I'll finally end with the procedure that you need to follow if you want to get a scheme. So let's kick off. What is a scheme? At its simplest, a scheme is simply a document that amends a charity's constitution. And there are 2 main types of scheme. Firstly, a si pre scheme, and secondly, an administrative scheme. Sometimes this second option is called a regulatory scheme or a managerial scheme. They're all the same. Si pre is a Norman French word that means as near as possible. And the idea is it's as near as possible to the original purposes. And in the recent Children's Investment Fund case, the Court of Appeal neatly summarised the difference between these 2 types of scheme. A si pre scheme involves altering a charity's purposes. An administrative scheme enables changes to be made to the administrative provisions governing a charity. So that's what a scheme is, but who can ask for one? Well, it's well known that a scheme can be made for unincorporated charities. But historically, there was some uncertainty about whether a scheme could also be made for incorporated charities. Fortunately, the new Section 75ZA of the Charities Act 2011 puts this to bed. This section confirms that it has always been possible to make a scheme for an incorporated charity. That includes CIOs. However, please note that the Commission's general policy is that it will only make a scheme for a corporate charity in exceptional circumstances. There are 2 other relevant points here. Firstly, Section 5 of the Charities Act 2022 has watered down the restrictions on when the Commission may make a scheme for a charity that's been established by Act of Parliament. In short, the process is that the Commission may draft and propose the scheme, but it needs to be approved by an order of the Secretary of State to have effect. A similar procedure applies for charities established by a royal charter. Again, the Commission can draft and propose the scheme, but it doesn't take effect until the King amends that royal charter by order in council. So the answer to the question at the top of the slide is pretty much all charities. So that's the what and the who. Let's move on to the when. There are an infinite number of possible situations in which a charity might want to apply for a scheme, and quite a long list is given in the Hailsbury's Laws of England paragraph on the slide, but I'll give you some examples. For example, you might need a scheme if you want to alter clauses in a governing document relating to designated land, or if you want to alter a dissolution clause, or if you want to remove the rights that a third party has under a governing document without that third party's consent, or if you want to save a charitable gift for which the original purposes have failed or become frustrated by recent events. On the other hand, similarly, there are many situations in which you might not need a scheme, and a few examples are given in the Hailsbury's Laws of England paragraph on the slide. But to give you some examples today, if the gift is for charitable purposes outside the jurisdiction, then you're unlikely to get a scheme in England. If there is actually just a dispute over the ownership of property or the very existence of a trust, then in practice that needs to be litigated before any scheme can be made. Thirdly, if the charity trustees have lost the governing documents, then first they need to go through the process of trying to work out what the original purposes were and persuading the commission or the court what they were, before you can then go on to the scheme process. Fourthly, and this is probably the most restrictive in practice, if there is a simpler or quicker method of achieving the change that you want, then in practice, a scheme isn't going to be the one thing you need. For example, if there's a power of amendment in the governing document, or if you can use one of the statutory powers of amendment, that's usually the appropriate answer. Now, sometimes trustees want to make a range of changes. Some things they can do themselves, some things they can't. In that situation, the commission and the court will still expect the trustees to make the changes they can for themselves and then only seek the scheme for the rest. Finally, there's this halfway house in section 75 of the Charities Act. In a nutshell, if a si pre occasion has not yet occurred, but in practice, the whole of the charity's income cannot effectively be applied to its purposes, then the commission may make an interim order. And what this allows the trustees to do is to spend some of the current income of the charity on the purposes which a scheme might order in future. So that's why it's sort of a halfway house. Now, with those introductory points out the way, let's turn to the detail. And we'll start with si pre schemes. Now, I know some of this will be very familiar to you, but please remember the law was amended on the 31st of October last year by sections 6, 7 and 8 of the Charities Act 2022. Also, a very important general point to bear in mind is that if a si pre occasion has arisen, then charity trustees are under a duty to secure the effective use of the charity's assets. It's not something they should just consider or think about doing. This is a duty. It's important. Now, there are two main situations in which a si pre scheme might be needed. Firstly, if the charitable gift has initially failed, and secondly, if certain subsequent events frustrate the charity's current purposes. Now, the former is largely governed by common law and the latter is largely governed by statute, and I'll explain them in that order. So let's start with initial failure. To seek a scheme for initial failure, you need to show two things. Firstly, obviously, that the gift has initially failed, and secondly, that the donor has a general or paramount charitable intention. Now, these types of cases typically concern gifts in wills, but they're not necessarily limited to that situation. And I'll explain what those two requirements mean in turn now. So what does the phrase initial failure mean? A gift will initially fail if there is no reasonable prospect of the gift being carried into effect, even if only in the future. Now, you assess this at the time the gift is made. So that means even if later down the line, something happens which renders it impossible to complete the purpose, you can't look back with the benefit in hindsight and say, well, all along, it was impossible. That's not the test. The test is applied at the time the gift is made. And this is a high bar. There's a case that concerns a gift in 1780 to fund a new bishop's diocese in America. Now, at that point, there were no bishops at all in America, and the court found there was the least likelihood of there ever being one. Even though those two things were found, that was still not enough for initial failure, because there was a chance that this could change. That said, the following situations are the types of things you've got to look out for when considering initial failure. If money is donated to a specific purpose which is illegal, but there are wider purposes which are not illegal, then you might get initial failure. In fact, this is what our friend Modestinus in Roman law was talking about. Secondly, if the gift is made to an institution which never existed, then that can be a case of initial failure. Thirdly, if money is donated to build something, but no suitable site can be found, then again, that could be initial failure. And fourthly, if money is donated conditional on certain people accepting the office of trusteeship, but they either can't or won't do it, again, that could be initial failure. But there are a couple of situations that will not count as initial failure. As the brackets in number 2 suggest, if the gift is to an institution which only later shuts down, that is not enough for initial failure. Similarly, if the gift is to a charity which simply changes its name lawfully, or even changes its purposes lawfully, that is also not initial failure. That's the first requirement, initial failure. The second requirement is general charitable intention. Now, this phrase has been explained in various ways in different cases, but fortunately, they are all getting at the same idea. And the basic idea is, are the words which cause the gift to fail merely the machinery for achieving the gift, or are they the substance of the gift itself? Now, this doesn't mean the donor needs to have an intention to benefit any type of charity anywhere in the country. It just means their intention needs to be wider than the specific failed purpose. For example, was the gift really to one specific school that never existed? Or was it really to benefit educational charities generally, or educational charities in a particular area? Now, to decide if a donor had a general charitable intention, you need to look at various things, including the whole of the relevant document or the relevant conversation, the nature of the proposed charity, and what's involved in the donor's plan or project. It's also relevant that the donor made other charitable gifts at the same time, but please bear in mind, this is not conclusive. This is just one factor. So those are the common law rules relating to general charitable intention. Those common law rules are now supplemented by statute in the new Section 63A of the Charities Act 2011, which came into force last October. In a nutshell, this section deems a donor to have had an intention to gift charitable purposes generally in 4 situations. And they're a bit complicated, but they'll come out on the slide. First situation is the donor will have that intention if the commission makes an order to that effect. And the commission will make that order if either it believes it would be unreasonable for the charity to incur the expense of trying to return the money, or the charity commission believes it will be unreasonable for the donor to expect the money back, for example, because the relevant events happened years ago. The second situation is if the gift was for £120 or less, the trustees reasonably believe the donor gave no more than £120 that year to the charity, and there was no condition requiring the money to come back if the purpose failed. Fortunately, the third situation is more straightforward. It's just if you can't find the donor. The fourth situation is if the property in question is a certain nature. So if the property is cash, which was collected in a way that means you can't distinguish one donation from another, the classic example being donation boxes, or if the property is the product of prize winnings, then in those situations, the donor is deemed to have a charitable purposes generally intention. So that's the first category of CPRE, initial failure. Let's move on to the second category, which relates to events after the gift. Now, importantly, the jurisdiction here might decrease in practice because when sections 280A and 280B of the Charities Act come into force in autumn, they will give trustees much wider powers of amendment. So in practice, you might not need these types of schemes so often. Nevertheless, if you do want to go down this route, you need to show 2 things. Firstly, one of the CPRE occasions in section 62 of the Charities Act has occurred. And secondly, that the original gift was unconditional. In other words, the donor didn't intend to get their money back. if the purpose subsequently failed. Now, this is not the same thing as a general charitable intention. It's a much lower, easier threshold. In practice, the difficulty here is with limb 1, the see, pray occasions. And that's what I'll talk to you about over the next few slides. Section 62(1) of the Charities Act lists 10 different see, pray occasions. And in general terms, what they all are getting at is situations in which the underlying purpose of the gift has been frustrated by subsequent events. But importantly, you only need to satisfy one of these situations. You don't need to satisfy 10. But I'll take you through them all. The first see, pray occasion is that the charity's purposes have wholly or partially been fulfilled as far as possible. For example, if you leave a donation to a church to pay off a debt, but the church has already cleared most of that debt, you might fall within this situation. Our second see, pray occasion is if the charity's purposes cannot be carried out either at all or in accordance with the donor's intentions and the spirit of the gift. Now, the phrase "the spirit of the gift" comes up a lot here, and it's simply the basic underlying intention for the gift. In other words, the substance of really what the donor was trying to do, rather than the form. And you infer that spirit of the gift from the terms of the gift, the charity's records, and how the charity has been administered over time. To give you an example of this see, pray occasion at work, there was a case in which a charity was only allowed to pay out a stipend of £3 a year to a preacher. That obviously became uneconomic, and this head of see, pray was used to increase that limit. Our third see, pray occasion is where the charity's purposes only provide for a use of part of the money. In practice, this is really concerned with surplus funds at the end of fundraising appeals. Our fourth see, pray occasion is that the charity's property could be used more effectively in conjunction with the property of another charity with similar purposes. In short, this is about consolidating two or more charities. Now, in deciding whether the effectiveness criterion is met, you need to consider the appropriate considerations. That's another phrase that comes up several times in this Act. And the appropriate considerations are listed as two things. Firstly, the spirit of the gift, and secondly, the current social and economic circumstances. Now, we've already mentioned what the spirit of the gift is on the previous slide, same principles here. But the current social and economic circumstances is really asking whether the ongoing usefulness of the charity's trust is continuing. The first tier tribunal has told us that in making that assessment, you can take a broad view of the current position. It's not just economic and social circumstances. You can look at environmental factors, legal factors, scientific factors, technological factors. For example, in Alice, the case concerned whether two schools that operated in different areas should be merged. The tribunal held that it didn't matter that they had different ethoses, different uniforms, different curricula. What mattered was their purposes were similar and the money could be used more effectively if they were merged. And so they were. Our fifth see, pray occasion is that the charity's purposes were laid down by reference to an area which has ceased to be a unit for some purpose. Now, in practice, this is most likely to be concerned with local authority boundary changes. Our sixth see, pray occasion is something similar. There is a separate power for the court to increase the area of benefit of a local charity if the boundaries of the local authority in which it operates are expanded. Our seventh see, pray occasion is that the charity's purposes were laid down by reference to a class of persons or an area which has, for any reason, ceased to be suitable. Now, in deciding the suitability criterion, again, you need to look at the appropriate considerations, those two things I mentioned just now. To give you an example, this see, pray occasion was used where the number of potential beneficiaries in the relevant area dropped dramatically, and that meant that the charity had far more money than it would ever need to support those beneficiaries. In that case, then, the area of benefit was expanded to ensure that the money was put to good use. Our eighth see, pray occasion is that the charity's purposes have been adequately provided for by other means. Now, in practice, this usually arises where the local authority housing services or state benefits supplement or even replace the work that the charity was doing in the local area. Our ninth CPRE occasion is that the charity's purposes have ceased to be charitable as a matter of law, for example, because they've become useless or harmful to the community. Now, this is likely to be pretty rare, but one example I found was in 1997, the Charity Commission decided that from then on, rifle or pistol clubs, which were not associated with military organisations or educational establishments, would no longer be charitable. Our 10th and final CPRE occasion is that the charity's purposes ceased in any other way to provide a suitable and effective method of using the charity's property. Now, this on its face is the widest CPRE occasion, and as a result, it's the ground that it's most commonly relied on. However, please bear in mind, the test is not simply whether the purposes are now less suitable and effective, it's whether they're suitable and effective at all. Now, you don't need to show that the purposes are impossible, but the bar is still high. And in deciding the suitable and effectiveness of the purposes, you need to consider, once again, the appropriate considerations, which we discussed earlier. But also, don't overlook the word ceased. That means if the purposes never provided a suitable and effective method of using the property, you can't rely on this head. You have to rely on something else. But this might be appropriate in certain cases. For example, in Vasani and Jasani, the court used this CPRE occasion to justify splitting a religious organisation into two separate organisations where a fundamental divide of opinion had arisen between two groups of members. So those are our CPRE occasions. Once they've arisen, technically, Section 67(1) of the Charities Act gives the Commission a discretion whether or not to make a scheme, because it uses the word may in may make a scheme. But in reality, if a CPRE occasion has occurred, then the Commission is very likely to want to do something about it. And in deciding what it wants to do, the Commission is required to consider at least three things. Firstly, the spirit of the original gift. Secondly, the desirability of securing that the charity's property is used for purposes which are, as far as reasonably practicable, similar to the original purposes. And thirdly, the need for the purposes to be suitable and effective in light of the current social and economic considerations. Now, we've considered these points before. They're really rehashing some of the principles we've considered earlier on, and the law is pretty much the same. But it's also useful to bear in mind the Commission's general policy. It says that it will be flexible and imaginative in applying the CPRE doctrine, balancing on the one hand usefulness and practicality with, on the other hand, respect for the existing purposes and beneficiaries. So that is the law of CPRE, and we've got through a lot, but you'll be delighted to hear that the law relating to administrative schemes is much, much easier. An administrative scheme may be made where it is expedient in the interests of the charity. Now, generally, the Commission and the court will be slow to thwart the donor's wishes, but really expediency is the test. And let me give you some examples of situations in which the court or the Commission might make an administrative scheme. For example, if the trustees want to remove a direction that the charity's property should be distributed within a certain period, or if they want to remove the prohibition on trustees benefiting from the charity's property. Or, and this is quite a common situation, if you need the Commission to define the charities which should receive a legacy which is left on trust to such charities as John Smith selects, but John Smith dies before making the selection. That's not a case of initial failure. This is an administrative scheme. All the Commission is doing is telling you who to pay. My final topic is procedure. How do you actually get a scheme? Well, the starting point is that unless the case is particularly contentious or involves difficult questions of law or fact, the Commission has the same jurisdiction as the High Court to make a scheme. And in practice, it's almost always cheaper to try going down the Commission route than the court route. Before applying, though, for a scheme, trustees are usually expected to carry out a genuine and appropriate consultation exercise with two groups of people. Firstly, any people who'd be affected by the change, and secondly, any people who have an interest in the charity that might change. Now, there's no prescribed form of consultation, but the Commission gives various examples on its website. For example, you could publish details on appropriate websites or in local media. You could host open days or meetings with staff, focus groups, or the public, or you could use questionnaires or local referenda. Once you've carried out that consultation, you can then apply for free to the Commission using that website or by email. Now, your application should explain what consultation took place, what responses you got, and how you took those into account. If the Commission is persuaded that it should, in theory, make a scheme, then in certain cases, it will also invite a second round of representations, usually for about 4 to 6 weeks. And the types of changes that the Commission will want consultation for are changes to the use of community assets, or to the disposal of designated land, or to the displacement of beneficiaries, or material changes to the objects of the charity. Also, if the scheme has generated significant public interest for whatever reason, again, the Commission is likely to go through its own consultation process. And the Commission will consider every submission and respond to every submission before it takes its decision. But once you've gone through all of that, the Commission will then draft the scheme. Although the Commission will work with the trustees and their advisors on specific wording, in almost all cases, the Commission will want to draft its own scheme using its own precedents. Once the scheme has been sealed, the Commission will post it on its website for 3 months, and any local charities are usually required to display it in a convenient local place for a month. But in all cases, trustees should keep the scheme secure and safe with their governing documents, because if you lose it, you might have to go through the whole process again. And with that warning ringing in your ears, I've come to the end of my talk. Thank you very much for listening.
That brings us to the end of this webinar. So thank you very much for joining us. Our next junior programme will be held in person in July. I think there are 2 events. One is going to be about insolvency and the other about litigation. You can also find all of our previous junior programmes on our YouTube channel. I think it was updated yesterday with the latest one. So thank you very much and hopefully see you soon.
Bye-bye.